Welcome once again to Lehto's Law. Here's Steve Lehto.
Jay tipped me off to a story out of Arkansas. And he said, Steve, check it out. It's a used car sale. And the case made it to the Arkansas Court of Appeals. And it's a fascinating case because mistakes were made on both sides. So we can learn from this. It's good if we learn from other people's mistakes because it saves us the embarrassment of making mistakes ourselves. The case is called America's Pre-Owned Selection versus Williams. And Jay pointed out that a POS is the acronym you get from America's Pre-Owned Selection. And of course, POS can stand for point of sale. So I think there's other things it can stand for too. But the cause of action arises from the purchase of two vehicles by Williams. And I'm referring to Williams as the buyer and POS as the seller. And asserting that the seller did not tender conforming goods and engaged in deceptive trade practices, Williams, who is the buyer, attempted to rescind her contract of purchase for both vehicles. When she returned to the first car and the dealership repossessed the second, she brought this case to recover her down payment and sought punitive damages. The trial court ruled in Williams' favor, awarding her almost $5,000 on the down payment and $3,500 in punitive damages, for which a POS now appeals. But this court affirms this and says, no, the buyer wins here. But these facts are convoluted, but they're entertaining. On March 13th, 2017, the buyer purchased a 2011 Dodge Charger from the seller. At trial, testimony established that Williams saw the car advertised on Facebook, drove to the dealership in Little Rock, and asked to see the car. She was told the car was being detailed, but the salesperson offered to begin the paperwork so that once it was out, she could be on her way. He told her the Dodge had been serviced and was in good condition. Without having first seen or driven the car, the buyer handed the salesperson her debit card, and the buyer testified that she tendered $4,575 as a down payment for the Charger. The car then came out of detail. Now, here's the problem. You don't buy cars without test driving them. You don't buy cars without having them inspected. You certainly don't buy them sight unseen. But she did that here. Now, the fascinating story here is that she managed to land on her feet at the end of the story. But it doesn't always go this way, as you can imagine. So when the car came out of detail, the buyer finished signing the paperwork, and among the papers was a document saying the vehicle is being sold as is. Now, here, the court determined that the seller would not let her inspect or test drive the car. They would not let her do that. So I would have advised her, if I'd been standing there, which I wasn't, that you do not give them a penny until you've inspected and test driven the car. She says they wouldn't let her do that. So my answer to that would be get up and walk out, but she didn't. She says she asked for her money back, but was told there's nothing they could do because they'd already debited her card. So she left with the car, and it broke down on her drive home. They sold her a car that didn't make it home. Now, generally speaking, if you buy an as-is vehicle, there's no guarantee it'll make it home. There's no guarantee it'll get off the lot. I've spoken to people who say, well, Steve, it's got to get off the lot. No, it doesn't. What people are thinking there is the idea that the buyer's got to take possession of it. And some people think, well, if it doesn't get off the lot, the seller still has possession. No, if it's been signed over to you and you paid for it and have the keys and you're driving it, it's your car. So in this case, though, she says they wouldn't let her inspect the vehicle. They wouldn't let her test drive the car, but they'd already taken her money. And that's what's going to save her here, because she then called the dealership several times asking for help, but they hung up on her, which is never a good look. She called her uncle, and he drove out and towed her and the car home. She then tried getting the Charger plated, but there were issues with the bill of sale, the vehicle identification number, and the car description. So that's another problem. Generally speaking, when somebody sells you a car and they're a dealer, they're required to take the steps necessary to allow you to get the car titled and plated in your name. And if you can't do that, then they've actually failed in their obligation under the sales contract. So she then had the car towed back to a POS, and she testified that when she arrived at the dealership, they told her they could just trade her car out with another, but they gave her no choice, and they just said, you get this car. They would not refund her money from the Charger. She stated they were hostile and said she could take either what they gave her or walk back to Jonesboro, which apparently is not next door, And she testified that she signed all the paperwork for the replacement car, which is a 2011 Hyundai Sonata. But after she finished signing it, the salesperson snatched the paperwork out of her hand and wrote a disclaimer on the document after she'd signed it. To which they wrote, "This vehicle is sold as is," and some other stuff about problems with the car. As you can imagine, if you propose a contract to me and I sign it and I hand it back to you and you make an alteration and you sign it, that's not a valid contract. We both have to agree to the terms at the same time. You can't change the wording on the contract. Yeah, but you signed it. She then drove the Sonata home but never registered it and never made payments on it. A POS repossessed the car 14 days later. Thereafter, she brought suit against the dealership seeking revocation of the purchase contracts, asserting fraud and misrepresentation, and requesting damages. And at trial, in addition to what you just heard, the manager of a POS testified that she did not know what the salesperson told Williams, the buyer, the day she purchased the Charger, but that she told the Williams that the car was sold as is, and Williams called after she left the dealership saying the tire blew out and she could not afford the gas for the Charger. She said that Williams, the buyer, wanted the Sonata because she wanted a newer-looking car, and they did the buyer a favor by letting her swap the vehicles. She said that Williams drove the Charger back to the dealership, and after they resold it, they received no complaints about it. The seller testified that as is was carefully explained to Williams because they explained that to all of their customers, and Williams was never forced to buy a car or forced to sign paperwork. Now, here's the deal. The court found, and this is a trial court, that the buyer met her burden of proof to revoke her acceptance of the contracts and to prove both fraud and violation of the Arkansas Deceptive Trade Practices Act, and awarded her the $8,000, which was her down payment along with a bunch of other stuff, and $3,500 in punitive damages for fraud. And all of that was appealed by a POS. On appeal, it argues that the findings for rescission, fraud, and violation are not supported by the evidence, and that the damages were therefore improperly awarded. And by the way, revocation is the idea, and rescission is similar. Rescission is talking about the contract. Revocation is talking about the object itself. But rescission is the idea that you can rescind a contract, you can cancel a contract, or undo a contract after the fact because of something that happened. And revocation of acceptance is, I have something in my possession, I bought it from you, but it doesn't conform to the contract in some way. I'm going to give it back to you. I want my money back. And you can do that except when you buy something as is. In a typical as is transaction, you're buying it with all faults. So you can't simply return it because it doesn't work. But her argument that they took her money but wouldn't let her inspect the vehicle is going to be very, very important here. A POS appeals a judgment of damages from a breach of contract cause of action. In appeals from this trial, they talk about the different standards they look at. And the appellant frames its arguments in the following 4 points: that the lower court made a mistake in finding that the buyer was forced to sign the contract. The trial court made a mistake in finding there was sufficient evidence to find that the seller committed fraud. The lower court made a mistake in its finding that the Dodge Charger was traded in for the Hyundai, then concluded that any claims concerning that first car should not have been heard by the court. And the lower court made a mistake in its finding that the buyer presented sufficient evidence to prove that she revoked her acceptance of the cars. And then it actually has a fifth point, despite the fact they said the following 4 points. So the math is not good here, but it's not important. For the first 3 points, the appellant, which is the seller, cites no legal authority to support its arguments. The court may refuse to consider an argument when an appellant fails to cite any legal authority. But the court says, that ain't good. The fourth argument, though, is that the buyer presented insufficient proof that she revoked her acceptance. But this court says no. They find that a POS committed fraud and likewise hold that it was correct to the lower court to find that rescission of the contracts was appropriate. In another point, the seller contends it was error for the lower court to find that it violated the Arkansas Deceptive Trade Practices Act. But that statute talks about how a private remedy is established for any person who suffers actual damage as a result of an offense or violation as defined in this chapter. A person has a cause of action to recover actual damages if appropriate and reasonable attorney fees. Here, the seller did not make any argument regarding whether the buyer suffered actual damage or injury, and instead simply stated that there was no remedy for any party who is not the Attorney General. Many states have Unfair and Deceptive Trade Practices Act. Arkansas's got one, Michigan's got one, and they're all modeled similarly. And quite often they'll say that the Attorney General of the state can step in and enforce this act against any merchant in the state. Or a private individual who is hurt by a violation of the act can also file a lawsuit. But those things are usually cumulative, meaning that one can do it or the other can do it. Here they're going, no, private individuals can't do this. And of course, there's cases on point that say they can, so it's a weak argument. But a POS argues that there was not proper proof on the damages, but they say that the buyer testified she had a down payment of $4,500, and she also lost $386 that was apparently charged for something else. And the dealership wound up taking the car back, the second car, so she had no car at all. So she's obviously out $5,000. That's roughly what it adds up to. The $3,500 in damages as punitive was found by the court, saying that the buyer had been defrauded, and the purpose of punitive damages is deterrence and punishment of wrongdoing. So the court found that there was certainly evidence of fraud here and bad acts. And so now, I know a lot of people are going to immediately jump back to and say, look, she bought a car without inspecting it. Well, the first car that she went to look at, you can understand what happened there a little bit. Because she goes to look at the car, it's late at night. She says, I want to buy this car, I want to, whatever. And they say, okay. And while she's talking to them, they get her to pay them some money. And then they say, oh, but you can't inspect the car, you can't drive the car, you got to sign some documents. Now, again, you or I might not do that. You or I might have said, no, I'm not going to give you a penny until I see the car and inspect the car. But the point is that they did that, and they got to live with the consequences. Now, the other problem, of course, is that when they say, okay, fine, we'll take the first car back, we're going to put you in a second car. They put her in a second car, and after she signed the contract, they changed the language on the contract. And this is stuff that it shouldn't take an attorney to understand and try to explain to somebody, okay? So most car dealerships don't actually have attorneys sitting there reviewing their documents for them. But I've known attorneys who represent car dealers, and they'll get a phone call every now and then from their dealer going, hey, I got a question for you about this or that or the other thing. And I suspect that once in a while that even the attorney come in and maybe give a little refresher courses to the salespeople. I mean, they ought to. But basic contract law, you understand this. This is something I think the sixth graders would understand, is that if a contract is an agreement on a piece of paper that you and I both agree to, right? I write something down and I sign it. I give it to you. You sign it. Boom, it's a contract. The idea that you hand me something that's been pre-printed, I sign it, I hand it back to you, and then you scribble something in and then sign it. It's not a contract. So that's a problem. That's a problem. So it's a crazy, crazy case. It's out of Arkansas, but the consumer won the case. And it's interesting because you have a win for a consumer buying a used car as is at night, sight unseen. Normally, you'd never get that. But right now, I assure you, across Arkansas, there are car dealers and car dealer associations who are screaming and yelling and pulling their hair out right now because this case is going to publicize the fact that car dealers who do bad things can be forced to pay for them in court. So here's the deal. This just went to the Arkansas Court of Appeals. I assume the state of Arkansas has got a Supreme Court also. They must. So I suspect that someone might try appealing this to them and see what happens. I wouldn't be surprised if some car dealer associations push for that because they don't want this being the final word on this case. But if it becomes that, again, it's a big win for consumers, and it's kind of a bad day for the car dealers down in Arkansas, especially those who sell the POSs. America's pre-owned selection, a POS. Versus Francesca Williams is the case. Jay sent it to me. Appeal from the Pulaski County Circuit Court, 12th Division, and the case opinion was delivered just February of 2021. Great case out of Arkansas. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The other day, I held the door open for a clown. It was a nice jester.